Elizabeth Lincecum, Communications Director at the North Carolina Institute for Constitutional Law. Welcome back to our series Cornerstone Commentaries. Today our guest is Justice Robert F. Orr, Senior Counsel and Executive Director of the Institute. He will discuss a proposed constitutional amendment on judicial terms.
House Bill 99 is a proposed amendment to the North Carolina Constitution that would change when appellate judges are required to run after they've been appointed to fill a vacancy. Currently, in Article 4, Section 19 of the North Carolina Constitution, if a vacancy occurs, the governor appoints to fill that vacancy on the Supreme Court or the Court of Appeals. And assuming that the vacancy has occurred more than 60 days before the next general election, the new appointee is required to run at that general election. What that has meant, and what we've seen over a period of time, is that judges who have 90, 120 days to not only learn about their new job and try and start doing a good job, but are also faced with the incredibly difficult task of trying to prepare a statewide campaign, are at an incredible disadvantage. Therefore, the purpose behind this proposed constitutional amendment is to give the new appointee more time to concentrate on doing a good job as a judge and to start thinking about and preparing for a statewide election. The appointee under the proposed amendment would run not at the next general election, but the general election following the next one. So arguably, at least 2 years would be available for this judge, the new appointee, to work on the election and also to concentrate on doing a good job as a judge. This is a good government proposal. Hopefully the General Assembly will pass it, and then it would be submitted to the voters for approval for amendment to the Constitution.
Okay. Thanks for joining us, and remember, the Constitution is the cornerstone of all law.
Actually.